My name is Terez Dunn with Dunn Explaining Probate. What if I told you there are three proven ways to skip probate in Georgia, but only one will protect you and your family? Today, I'm going to break down each method so that you can choose the right strategy for you and your family situation. Again, my name is Terez Dunn. I'm a real estate agent here in Georgia, and I've seen firsthand which probate avoidance strategies work and which ones create very expensive problems. I'm going to give you real examples of when each one of these strategies work and when it's not such a good idea. And by the end of the video, you'll know exactly which probate avoidance strategy makes sense for you and your family's situation. The first method is joint ownership, which is really simple, but it can be risky. Joint ownership with rights of survivorship means that two people own an asset together, and when one owner dies, the survivor automatically owns everything and there's no probate needed. This method works really good when there's a married couple, and most married couples in Georgia own their home jointly. So when one spouse dies, the other automatically owns the entire house. There's no court, there's no delays, and there's no probate costs. To give you an example, I've seen countless Georgia couples use this successfully. When the husband or the wife passes away, the spouse already owns the house jointly, so they can continue living there, they can sell it, or they can refinance it immediately. So basically, when joint ownership works, this is between, like I said, married couples. This is almost always the right choice when both owners live together in the property and when there's no credit concerns, when the joint owner, or both owners for that matter, have clean finances. Now, where this can become a problem is maybe adding adult children. The reason some parents do this is because they think by adding the kids to the deed, they'll avoid probate by doing this. This is something that happens frequently, especially after parents hear about how much probate costs. There's three major risks with adding adults. One is credit exposure. The moment that you add your child as a joint owner and they legally own part of your house, if they get sued, if they go through bankruptcy or have a tax lien, creditors can come after their ownership share. And to give you a real life example, there was a Gwinnett County family where the mother added her son to the house deed. 2 years later, the son went through a messy divorce, and his wife's attorney claimed half of his share of the house, which was his mom's house. So this became a nightmare. Another risk when you do joint ownership and you add your adult children is there can be divorce complications. If the joint owner child gets divorced, their spouse may have claim to the property and automatically get a share of the inheritance. And the last risk is you lose control. So when you add a joint owner, you can't sell or refinance the house without their signature. So what if you need to sell the house for healthcare costs and your child refuses to sign? You're stuck because you're going to need their signature. Another example is there was a client in DeKalb County and she wanted to sell her house to move to assisted living. So she added her daughter as a joint owner years earlier, and the daughter, she was going through financial problems and didn't want to sell because she needed somewhere to live. So this meant that the mother couldn't sell her own home. So these are examples when joint ownership actually fails. Adding your adult children, it can create too many risks. If there's more than one owner, it's going to require both signatures. There's credit problems. It exposes the property to claims. So if there's any kind of complex family situation, that's probably not going to be your best option. Bottom line is joint ownership is great between spouses, but it's going to be risky with adult children. So let's take a look at our next option. Option number 2 is to have beneficiary designation. This is very easy, but there's limitations to it. So some assets let you name who get those assets when you die, such as life insurance, retirement accounts like a 401k or an IRA. Fill out a form naming the beneficiaries, and when you die, those people get the money directly. No probate. This works well for married couples. Again, this is perfect. You name your spouse as the beneficiary on your 401k. When you die, they get the money within a few weeks. Unlike joint ownership, no court involvement. And unlike the first method we just talked about, this is also good for adult children as well. This can work great with responsible adult children who don't have creditor issues. You name them on the life insurance they collect when you pass. Now, beneficiary designations are probably not a good idea when there are going to be minor children involved. It's going to create a conservatorship problem. Also, complex family situations such as death order may arise, creditor concerns, there's no protection available, and real estate cannot be used for property. So let's take a look at some of these examples I just gave you. The first problem is a minor child cannot inherit property. And here's what most parents don't realize. If your child is under 18, they legally can't receive money directly. And what happens instead, if you name, let's just say your child was 10 years old as the beneficiary on a $200,000 life insurance policy and you die, that money goes directly into court conservatorship. I also spoke about this in a previous video. When a minor child turns 18, more than likely they're still in high school. At this point, they receive a lump sum payment, sometimes 6 figures or more. And most 18-year-olds are not going to be responsible for this kind of money to fall into their laps. Conservatorship costs, as we talked in previous videos, they get to be kind of expensive. When your child turns 18, most times they're still in high school. If they come into a big windfall of money or a large inheritance at one time, being responsible is probably not going to be the first thing on their list. And the second problem is death order. Let's say someone dies in the wrong order and you leave an equal share to all three. One of the kids pass, then does it go to that deceased's child, to their kid, which is your grandchild? Well, that all depends. It depends on how you filled out the form at the financial institution and goes to the financial institution's default rule from there. Many parents accidentally disinherit grandchildren without even realizing it. Problem number 3, there's no creditor protection. When a beneficiary receives money directly, it's immediately available to their creditors. Here's another real situation I've seen. A father named his son as the beneficiary on a $150,000 IRA, and the son was going through bankruptcy when his father died. So the son received the money, and within 60 days, the bankruptcy trustee took most of it to pay his debts. Now, I'm sure that the father never intended for this money to go to his son's creditor. Another problem is outdated beneficiaries. Life always changes. There's divorce, there's remarriage, there's births, there's also deaths. Many people will forget to update the beneficiary form. And a common mistake is, and this has happened so many times, I can't count the number of times that this has happened. I've seen where someone gets divorced, they remarry, and they never update their 401k beneficiary. And when they die, their ex-spouse gets the money and not the current spouse. So this is not normal, but it has happened. The last problem is limited assets. You can only put your beneficiaries on certain things, such as life insurance, retirement accounts, and some bank accounts. And you can't put a beneficiary designation on your house, your car, or most other assets. As you see, joint ownership has its risks and beneficiary designation has its limitations. This brings me to a comprehensive solution. That is revocable living trust. So, what is a revocable living trust? If I can just kind of give you a real simple explanation, a trust is like creating a private container to hold your assets. You create this container with a private document and it's not filed with the government office, and then you put your assets into it. So, the benefit of this is when you die, the trust doesn't die. It's not a living thing. So your assets stay in the trust and there's no probate. Your chosen trustee just follows your written instructions. Think of it this way. If you own a house in your name and you die, we have to go through probate to transfer it. But if your trust owns the house and you die, the trust still exists. So the house stays in the trust name. Your trustee handles it according to your instructions and there's no court needed. This is how trust will solve every problem. The number one benefit is it avoids probate completely. Unlike a joint ownership, which still needs probate when both owners die, or beneficiary designation, which only works with certain assets, a trust will avoid probate for everything. This is huge if you own real estate in multiple states. So let's just say you own the property here in Georgia and Florida. Without a trust, the families would face a problem in both states. There's going to be double cost, double the time, and double the hassle. Let's just say you have a house here in Atlanta and a vacation condo in Destin. By putting both of these properties in a trust, your family will avoid probate in both states when you pass. The second benefit is you control what happens. Now, remember here in Georgia, the default rules split everything 50-50 between the spouse and the children. With the trust, you decide exactly where everything goes. Most married couples want everything to go to the surviving spouse first, and then the children when both are gone. A trust lets you do exactly that. The third benefit, this is where the trust really shines. Instead of the money going to a court conservatorship until age 18, you set your own rules. Most parents set up a trust that says, my child's inheritance stays in a trust with a trustee that I choose. That trustee will use the money for the child's health, for their education, and for support, but the children don't get direct access until they are more mature. Another great thing about this is you can set up a distribution schedule. A common approach would be your child gets, let's just say, 1/3 at age 25, 1/3 at age 30, and then they'll get the final third at 35. You may ask, why would I want to split up when they get the money? The wisdom of that is, at 25, there could be a possibility that there's been some financial decisions that were not good in their first distribution. If it goes 5 years later, they get their second distribution at 30, then they've had a little time to mature before getting the next portion, and so forth and so on. So they get two more distributions maybe after making a financial mistake. So I think many young adults learn from their mistakes, and by doing this, it will give them time to learn from their mistakes, if there are any. The next benefit is creditor protection. Unlike the last method that we talked about, where the creditors can take your distribution, this is powerful because if you leave money to someone directly through joint ownership or beneficiary designation, the creditors can grab it immediately. So how the trust works is you can say, I want this money available for my son's or daughter's benefit, but I don't want it available to his or her creditors. The trustee can pay for things your son or daughter needs, but the creditors can't seize the trust assets. Another real life story is there was a family where the father set up the trust for his daughter who was going through a divorce, and when he died, the inheritance stayed in the trust. The daughter's ex-spouse couldn't touch it, but she could still use it for her needs through the trustee. The next benefit is it handles any asset. So unlike beneficiary designation that only work for certain accounts, you can put anything in a trust. You can put houses, rental properties, investment accounts, business interests, everything you can think of. And the last benefit is you maintain your control. And here's what surprises people. Creating a trust doesn't change your control at all during your lifetime. You can buy and sell property in the trust name. You can refinance mortgages. You can change the trust terms at any time. You can close the trust if you want to. And you can make any financial decision that you would be able to make otherwise. A revocable living trust has no tax implications. No separate tax return is needed. Your accountant doesn't have to do anything different. It's completely neutral for tax purposes. So to create a trust, you create the trust document, which the attorney is going to draft. You're going to fund the trust, transferring assets into the trust name. You're going to maintain the trust, which just simply means you may update it as your life changes. And I've also worked with investors who put rental properties in trust, and it doesn't change their ability to manage properties, collect rent, or make decisions, but it provides massive benefits. So just to do like some side-by-side comparisons with the joint ownership, it's simple. There's no cost. It works great between spouses. Now it's risky with children. There's credit exposure. So this is going to be best for married couples. Beneficiary designation. It's easy to set up and it works for specific accounts, and it's best for simple situations with adult beneficiaries. And revocable trust is best for anyone with children, significant assets, or complex situations. So you may be asking, which one do I need? And you might use all three. And the smartest estate plans often use all three of these methods. An example of that would be you own your house jointly with a spouse. You name your spouse as the beneficiary on your 401k, and you put your rental properties in a trust. Then make sure your trust is the backup beneficiary on everything. So if your spouse isn't alive, assets go to the trust and your children's benefit. So you should choose a joint ownership when you're married and you're holding the property with your spouse. It's a very simple situation with no children or complex needs. I would choose a beneficiary designation when you're naming your spouse on retirement accounts and you're dealing with accounts that allow beneficiaries, and your beneficiaries are responsible adults without creditor issues. I would choose a trust if you have minor children, if you own multiple properties or significant assets and you want control on how and when beneficiaries receive money. You need creditor protection for your beneficiaries. You own property in multiple states and you have a complex family situation. You probably want to go with the trust. So each method has its own place, but trusts are going to provide the most comprehensive protection for most families. Setting up a trust, it is money up front. Typically, you're going to be looking at paying anywhere from $2,000 to $5,000 here in Georgia. But remember, in my previous videos, probate can cost you anywhere from $3,000 to $15,000 depending on the complexity of the estate. And it takes 12 to 18 months. So a trust is a one-time investment that saves your family multiples on that cost. And you should put an action plan in place. And that action plan this week should be review how you currently own your assets, check all beneficiary designations, consider whether your current setup protects your family. What you should do this month, I would consult a Georgia estate planning attorney, discuss which combinations of methods works for your situation, make a plan to implement the right strategy. And what you should do sometime before the year is over is complete your estate planning, fund your trust if you create one, update your beneficiary designations to coordinate with your plan. Estate planning isn't just about avoiding probate. It's about protecting the people that you love. The right strategy depends on your unique situation, but now you understand all three options and you can make an informed decision. As a real estate professional, I can help you understand how these strategies affect property ownership, but always work with a qualified Georgia estate planning attorney to implement these strategies correctly. If this video helped you understand probate avoidance, please like, subscribe, and share with anyone who owns property in Georgia. And check out my other videos about probate costs and estate planning strategies. And your family's future is too important to just leave it to chance. With that said, I'm done explaining probate.